I'm Pilar Marrero, Associate Editor of Ethnic Media Services, and your moderator for today. Today's briefing focuses on affirmative action. As you know, the U.S. Supreme Court is poised to rule before the end of June on 2 cases challenging the use of affirmative action in college admissions at Harvard University and the University of North Carolina. Most experts believe that the conservative majority, who holds a 6-3 advantage in the court, will rule against the schools, possibly dismantling a 40-year legal precedent that supports consideration of race in college admissions. Depending on how the court rules, the impact on diversity in higher education could be significant. Many schools that for the last 45 years have considered race as one factor in their assessment of applicants maintain that this is essential for building a diverse campus. States where affirmative action in college admissions has been already banned before, like California, have tried other measures to open access to minority students, but say that nothing works as well as race-informed affirmative action. Experts from some of the top civil rights and college access organizations in the country will explain the impact of the impending ruling and discuss alternatives to achieving diversity without this important tool. Our speakers include Lisa Holder, President of Equal Justice Society. Thomas A. Sáenz, President and General Counsel of the Mexican American Legal Defense and Educational Fund, MALDEF. John C. Jiang, President and Executive Director of Asian Americans Advancing Justice, Asian Americans Justice Center, and Michelle Siqueiros, President of the Campaign for College Opportunity. We ask that speakers speak slowly, as I'm doing, for our interpreters in Spanish, Mandarin, and Korean, and we ask reporters to enter questions in the chat. We will send a video of today's briefing and expanded bios with contact information for each speaker to all participants later today. And so without further ado, I'm going to invite Lisa Holder to please open the session. Lisa, you're welcome.
Thanks so much, Pilar. And I want to thank Ethnic Media Services for hosting the briefing on this critically important issue. My name is Lisa Holder. I am a civil rights attorney, a resident of the state of California, the Governor Newsom's appointee to the California Reparations Task Force, and I'm also the president of the Equal Justice Society, which is an Oakland-based racial and social justice organization that is transforming the nation's consciousness on race through law, social science, and the arts. And I appreciate the invitation to talk to you here today about what's happening with affirmative action. So we're here to talk about a possible negative ruling, but let's not assume that it's going to be negative. Do not prejudge the outcome. We're dealing with 2 cases, a case against Harvard and a case against the UNC. These cases are complex, they are multi-layered, and the 2 cases are divergent. They involve a divergent set of facts and divergent legal principles and legal reasoning. So we shouldn't assume that whatever decision comes down is going to be some uniform blanket opinion that eliminates or completely guts affirmative action. Also, the court is required to do its due diligence before even contemplating overturning over 50 years of precedent. And so in order for each member of this court to adequately vet this case and do its due diligence, they will have to use nuanced reasoning and opine in a sophisticated, multi-layered, and nuanced way. And so we should not expect for them to be, for it to be some uniform blanket elimination of affirmative action. This decision can come down in variegated ways, and I caution that we resist the urge to be reductionistic. At the same time, it's important to be prepared and to be proactive. And the Civil Rights Coalition that you see before you here today always prioritizes preparedness. We have to be prepared to protect and defend the civil rights gains in equity, belonging, and multiculturalism that our civil rights forebears fought and died for. And yes, one of those civil rights gains that our forebears fought and died for is affirmative action. Being prepared means being cohesive and united as a BIPOC and progressive coalition, and not letting anti-civil rights segregationists divide us along lines of class, race, and other superficial metrics. Progressives, patriots, and free thinkers of all colors and creeds and sexual orientations need to unite in the struggle to preserve the core American principles of inclusivity, multicultural democracy, and to preserve policies that block discrimination and abate the legacies of inequality. Affirmative action is the exemplar of such a policy. Now, as I said, I'm a resident of California, and I've been a longtime civil rights practitioner in the state of California. And so one of my value adds here is to bring a California-specific lens to the conversation and to look at the lessons learned from the setbacks that we faced in California and the 7 other states that banned affirmative action in the 90s and the early 2000s. In the state of California, we banned affirmative action in education, government hiring, and government contracting. In the business and contracting field, we saw that Black, Brown, and women-owned businesses were decimated by the ban on affirmative action. The Equal Justice Society commissioned a study that showed that Black, Brown, and women-owned businesses lost billions of dollars over the last 20 some odd years. And those businesses, which often were the only businesses that were serving marginalized and underserved communities, when those businesses failed, poverty deepened in marginalized and underserved communities, and the racial wealth gap, which had already been horrific, expanded because of the ban on affirmative action. In California, with respect to education, because of the ban on affirmative action in preschool through 12, we see that in preschool through 12, California is among the most segregated in the nation. So districts where Black and Brown students are being served are often majorly underfunded, to the tune of, some studies show, $14 million. There's a $14 million disparity between the school districts that served Black and Brown students versus the school districts that serve predominantly white districts. And without the critical tool to correct this inequality, which is affirmative action, we just see this segregation becoming more embedded in our pre-K through 12 schools. We're looking at apartheid schools where children of color and kids are not getting access to opportunity. That is un-American. Our public universities in the state of California as well became less diverse, and several generations of college students lost access to opportunity and educational benefits that diversity offers. Let's not forget that social science, there is consensus among social scientists that diverse educational environments are 35% more productive than homogeneous ones. For generations, our college students have lost the benefit of diversity in their education. Education is the great equalizer in the United States, and it cannot serve that function without discrimination blockers and tools that correct for legacies of inequality. Affirmative action is the exemplar of such a tool. The last thing I'll say is that we must continue to be innovative in our approach to expanding civil rights and multiculturalism, even in the face of adversity. The court's decision, no matter how it turns out, does not stop the struggle for equity, civil rights expansion, and multiculturalism. And there are myriad policies in addition to affirmative action that we must continue to push forward. These include other tools that increase equity and tools that target the most marginalized in our education system. So tools that desegregate our K through 12 have to be uplifted and expanded. We also need to look at eliminating standardized testing, such as the SAT and the ACT. EJS was one of the organizations that brought litigation against the UC system to eliminate the SAT and the ACT, and we won. And we were able to force the schools and compel the schools, all the public and public higher education across the state of California, to eliminate those barriers to access and education, which social science had proven were not adequate metrics of college preparedness. So we need to expand that movement to eliminate the SAT and the ACT. We also need to look at tools like reparations for Black students. And that includes targeted programs and scholarships that increase Black students' access to a fair education and access to opportunity. And finally, we have to look at a broader policy of expanding the court, of expanding the Supreme Court. And we shouldn't be afraid to look at that in this moment. If we see that our Supreme Court is susceptible to corruption and partisanship that interferes with the proper functioning of our democracy, then we need to consider expanding it to create an ideological balance consistent with the checks and balances construct that our government was founded on. Thank you.
Thank you. Thank you, Ms. Holder. There are some questions here in the chat. Peter, do you want to ask your question? Peter White?
I think I'm unmuted, yeah?
Yeah, we can hear you.
But it's an analogy, okay? So I live in Tennessee. So the legislature here has passed all kinds of anti-abortion legislation. Prior to the overturning of Roe v. Wade on this. So I'm wondering, turnabout is fair play. I'm wondering what progressives can do, in the states to protect it and advance it in the areas that we just heard about. But I don't see it happening, at least not in Tennessee.
Elisa, that's for you.
Well, one of the things that progressives can do is to organize and to mobilize and to vote. The power of the vote is sorely underestimated. And what I will tell you, using California as a case study, is that yes, over 25 years ago, we eliminated affirmative action in the state of California, but that was at a time when we had a very conservative legislative bloc in the state of California. And in the past 25 years, because of the efforts of progressives to vote and to engage in that way, we have been able to completely reverse what our legislature looks like, to the point where now in the state of California, we have a 2/3 majority of progressives in our legislature. And we are able to move forward on many equity measures that would have been impossible in a state with a conservative legislature.
Thank you.
Thank
And
you.
we're going to take one more question from Henrietta Burrows and then move on.
We can understand, Lisa, how affirmative action bans can affect higher education, but could you be more specific in terms of how it affects preschool through 12?
Well, thank you for that question, because I did talk in my comments about pre-K through 12 and how important it is that we maintain and have sustainable multiculturalism in that sector. And what happens in that sector is that you can have affirmative action measures to ensure that the schools are integrated. And even if the schools are racially or culturally segregated, you can have affirmative action to ensure that all schools are receiving equal resources, that they're receiving equal amounts of money from the government. And without affirmative action, right, as a correction for inequality, we no longer have that tool in the state of California. And so we are seeing segregation in our schools become more deeply embedded. And we're also seeing that resources within these segregated schools, we're seeing that major imbalance where Black and brown schools are receiving much fewer resources. And studies show that per student, the Black and brown students are receiving about $2,500 less per student annually.
Thank you, Ms. Holder. Let me call on Thomas A. Sands from Maldiv. Tom.
Thank you, Pilar, and thank you all for joining us today. I certainly appreciate Lisa's caution that we not assume an outcome, but my goal today is to ensure that you are prepared should the conservative Supreme Court issue a ruling that overturns the 45-year-old precedent in Bakke versus University of California Regents. Unfortunately, I consider that to be the likely outcome, given what we know about the conservative justices' prior views on the issue of race-conscious affirmative action. So without assuming an outcome, I want you to be prepared should the court do what it might do in overturning that 45-year-old precedent. Specifically, I want to cite from experience, largely experience from here in California where I sit. It's no coincidence that 3 of our 4 panelists today, Lisa, Michelle, and I, are in California because California was the first state 26 and a half years ago with Proposition 209 to eliminate race-conscious and gender-conscious affirmative action in education, employment, and contracting. So we saw firsthand in California how Prop 209 was overinterpreted, actually misinterpreted by those from the right and by others who are misinformed, so that its impact was greater than it should have been, because the myth about what Prop 209 meant overcame the reality of its proper interpretation. I am concerned that the same could happen here when folks from the right will positively assert that the decision means things that it most emphatically does not mean. So today I would like to highlight 3 likely myths that will be propagated about any decision from the Supreme Court that overturns the Bakke precedent. But before getting to those 3 myths, let me just emphasize how extraordinary it will be if the Supreme Court chooses to overturn Bakke. We all know that last year in Dobbs, this court overturned a 49-year-old precedent in Roe versus Wade. If they rule against race-conscious affirmative action, they will be overturning a 45-year-old precedent in Bakke versus UC Regents. Indeed, it's important to note that after Bakke, the court has already revisited the issue of race-conscious affirmative action at least 3 times. And on each of those occasions, the court majority reasserted that the Bakke precedent continues to be the law. The Bakke precedent allows limited, tailored consideration of race among other factors in making higher education admissions decisions. So overturning that precedent would be extraordinary and on a par with the Dobbs decision of last year. The 3 myths that I think we should be most careful to guard against are the following. First, this is not a case that will have anything to do with affirmative action in employment or contracting. This case is confined to education, and that is because the Supreme Court long ago established different tests for the constitutionality and legality of affirmative action in employment and contracting versus education. Indeed, in some ways, the Supreme Court already established more difficult tests to be satisfied to engage in affirmative action efforts in contracting or in employment. So this case will have nothing whatsoever to say about affirmative action in employment or contracting, and anyone who asserts otherwise is misleading you. Second, no matter what the court decides, it will not be a mandate in favor of race ignorance or race blindness, as it's sometimes called. We know from the experience in California that folks will assert, some of them with no base of knowledge whatsoever to back it up, that this decision means that policymakers cannot consider race or racial disparities in making decisions in education. Anyone who asserts that is lying. That is absolutely false. No matter how this decision comes out, it is not a directive to ignore race or the abundant racial disparities, many of which Lisa cataloged, that continue to exist in education and higher education across the country. Indeed, there remain federal and state laws that require policymakers to not only identify racial disparities, but to determine if they are unjustified, and if they are unjustified, to step in to eliminate those racial disparities in education and higher education. So complete opposite from what you will hear asserted. This is not a mandate of race ignorance or race blindness. It is instead a moral and legal directive for policymakers to attend to those ongoing disparities, but to do so with remedies that are race neutral. Third, this decision, no matter how it comes out, will have nothing to say about curriculum. You will hear folks from the right will assert that somehow this Supreme Court decision, if it strikes down race-conscious affirmative action, also means that ethnic studies, even critical race theory, must be eliminated from schools. Anyone who asserts that is lying. This decision will say nothing whatsoever about curriculum, but folks from the extreme right in particular will assert that it provides now court support for their ongoing assault on ethnic studies and CRT. By the court's own precedent, curriculum cannot have a race. So African American studies Black studies, Chicano studies, Latino studies, Asian American studies, even though they focus on the experiences of particular communities, the courses and the curriculum do not, as a legal matter, have a race. So including those courses is not at all race conscious in education. So to reiterate, please guard against and be prepared for the myth makers taking advantage and asserting that this case means that affirmative action in employment, contracting is dead, or assert that this decision means that all policymakers in education must be ignorant of race and not accord any attention to racial disparity. Or third, if they assert that this decision means that ethnic studies must be eliminated. Those are all falsehoods that will be perpetrated by those who seek to take unfair advantage from a misinterpretation of whatever the conservative court decides in these cases with respect to race-conscious admissions practices. Finally, we don't know when this decision will come down. There are many folks who assume, based on patterns in prior years, that because this is a controversial decision that may have a number of different justices' opinions attached to it, that it won't come until the end of June. But I caution you, it can come any day. As we are here today, these cases are the second oldest cases on the Supreme Court's docket. That means they are the cases that have been waiting the longest, second longest in this case, since they were argued before the court. These cases were argued on Halloween. So if past pattern prevails, this decision will not wait until the end of June, but could come any day. That's why I want to thank Sandy and Pilar for putting this program together. We all need to be prepared for the inevitable misinterpretation of the decision that will be purveyed by those on the extreme right. Thanks.
Thanks, Tom. In the interest of time, we're just going to go straight to John. John Yang.
Sure, thank you very much. My name is John Yang. I'm the President and Executive Director of Asian Americans Advancing Justice, AAJC, a civil rights organization based in Washington, D.C. I very much appreciate what Tom has said about the misinformation that is likely to come out of these decisions. What I would like to emphasize is some of the misinformation around these decisions themselves and where the Asian American community stands with respect to affirmative action and race-based policies. Look, our national future depends on racial equity and diversity in higher education to achieve a thriving multiracial democracy. And if these decisions limits or ends race-conscious admission policy, we will all suffer, particularly Black and Brown community, but Asian Americans as well.
Slow down a little bit, John.
Sorry.
Sorry.
Yes. We must all work together to achieve that goal, no matter how the Supreme Court rules. Diversity benefits everyone. It lends itself to new perspectives, empathy, better mental health, innovation, and economic growth. It is important to remember that talent is everywhere, and it is incumbent upon all of us to ensure that we create real pathways to opportunities. An important fact to note is that over 2/3 of Asian Americans support affirmative action and support race-conscious admissions policies. That means that Asian Americans likewise recognize the benefits of affirmative action, not only for our own communities, but for all communities. It is also important to recognize who is driving these lawsuits. The person that is driving these lawsuits is a person named Ed Bloom, a white male who is trying to weaponize these policies and trying to divide our communities. He purports to be representing Asian Americans, but he is not. What he is trying to do is dismantle affirmative action, race-conscious policies in a manner that will hurt all of us. It is also important to recognize that there are no students that have testified against the current race-based policies. Rather, the only students that have testified, including Asian American students, are students that have recognized the benefits of diversity, recognized how important it was to their educational experience. It is also important to recognize that the decisions that were issued by both the district court and the appellate court went through extensive fact-finding to determine that there was no intentional discrimination against Asian Americans, which is the basis of this lawsuit. In a 104-page district court opinion, and then in a, it was a 130-page district court opinion and a 104-page appellate court opinion, both courts went through the extensive record and recognized that there was not sufficient evidence of discrimination against Asian Americans, and rather that these policies were very narrowly tailored to design to serve the compelling interest of diversity on university campuses. Look, recognizing that considering race is one of many factors in the admissions process remains necessary to ensure that equally qualified students from communities of color have the same access as privileged white students. At Harvard, Asian American enrollment has increased significantly and now currently make up nearly 28% of the incoming Harvard class. The Harvard Asian American class has doubled in the last 30 years and has more than quadrupled over the time in which the Bakke decision was first issued. So any suggestion that somehow Asian Americans are being discriminated against is just belied by these simple facts. And if Harvard was to stop considering race, it would cause a significant decrease in the racial diversity of Harvard students. The share of Black students in the admitted class, for example, would decline from 14% to 6%, and the share of Latino students would decline from 14% to 9%. The Supreme Court has long recognized that colleges and universities have a compelling interest in the numerous benefits that flow from a diverse student body that is representative and reflective of our increasingly multiracial and pluralistic society. The evidence supplied by the opposition from the plaintiffs in this case have been refuted, and that is something we need to continually cite to, notwithstanding attempts by the plaintiffs to suggest that the record somehow proves discrimination. At the end of the day, we have to recognize that we are not in a race-blind society. Our lived experiences should not be up for debate and now threatened by those wanting to use the Asian American community for their own ill-gotten political gains. Race-conscious admissions policies have created superior learning environments for all students, including Asian Americans. Student body diversity promotes cross-racial understanding, reduces racial isolation and hostility, and better prepares students to become future leaders in our multicultural and global society. Thank you very much. I look forward to questions.
Thank you, John. Before moving on to Michelle, so I have a question. As all of you mentioned, the argument for the practice of using race is that campus diversity is a compelling interest because all students would receive a better education if exposed to different viewpoints. What do you all foresee as the impact if there's a complete ban on campuses? What would be the impact of this, in your opinion? I don't know, Lisa can start, and then Tom and John.
Again, California is the case study. So unfortunately, we have seen the impact, and we saw a unprecedented dramatic drop in our universities in terms of the numbers of Black and Brown students after the ban on affirmative action. And what I will tell you quickly from my own sort of lived experience and personal experience is that I've taught at universities and at law schools, and 5 years at Occidental and 3 years at UCLA Law. And so I've been able to do I have my own anecdotal predictions about what can happen. When my students were diverse in race, gender, sexual orientation, they showed up to class in a unique way. The debates were much more lively, much more interesting, and people sort of stepped up and were much more engaged. In my classes that were homogenous, you did not have that dynamic. You did not have that enhanced educational opportunity. So from my anecdotal experience, I can tell you it would have a dramatic impact on these learning environments, negative impact.
Thank you, Tom.
I think the universities would be devastated, not only in the fact that their numbers would drop, as Lisa has described, but in some cases they will artificially drop the numbers, and that will be direct and unconstitutional discrimination. They will artificially drop the numbers out of a fear that they will be sued by the same folks that John mentioned who pursued these cases against Harvard and UNC. So unfortunately, right now, there are counsel inside of institutions telling their presidents that they need to show a tangible drop in Black and Brown admissions, or they will make themselves the targets of a lawsuit by Ed Bloom and others who have led this assault on affirmative action. So we will see, frankly, an immediate increase in direct, unconstitutional, unlawful discrimination against Black and Latino applicants. But number two, the universities will suffer reputationally when they show those numbers. We know that education will suffer at Harvard, at UNC, and at other universities that somehow engineer a significant drop in their Black and Brown admissions, and their reputations will suffer. In this day and age, that is not an acceptable outcome. That's what Ed Bloom and the like don't get. As John described, all of the communities that are growing in this country support affirmative action. Those who are viewed as complicit in its elimination will suffer reputationally long-term.
Other thing I would add is our students will suffer. I don't understand how a student that is a senior in high school can describe their full experiences if they're a person of color, if we are living in a so-called race-blind, or I appreciate Tom's term, a race-ignorant society. I don't know how I would write an essay about who I am as an individual without talking about my race, without talking about my background. So I worry about the impact on our students and their experiences and how they value themselves in this type of a post-Harvard world that some of us are concerned about.
Thank you for your insights. Michelle Siqueiros, President of the Campaign for College Opportunity, please go ahead with your remarks.
Thank you, Pilar. It's a pleasure to be here with all of you today, and certainly difficult to follow Lisa, Tom, and John, but welcome this conversation. Appreciate that you're having it today. You know, equal opportunity for all and an inclusive democracy is a universal value, and we will keep advocating for inclusion and access for all communities in higher education, regardless of the Supreme Court's decision. As Tom shared, we're focused on making sure that any negative ruling is not an excuse or permission for universities and colleges to backslide on recent progress and return to an era of unchecked exclusion and segregation, which shuts out generations of Black, Latinx, Indigenous, and Asian American Pacific Islander students from higher education. And we know that systemic legacy of exclusion, it hasn't been that long since women, Black, Latino, Indigenous, and Asian American students were even permitted to attend our universities. Affirmative action in admissions has been one of the most powerful tools to address the lack of diversity on college campuses, as well as the centuries-long and ongoing legacy of racism and biases in higher education. But affirmative action alone was never intended to be the panacea. So we must do everything in our power to provide all students an equal opportunity to pursue a college education and to ensure that universities do not discriminate against Black, Latinx, Indigenous, and Asian American students because of this ruling. So we must really ask, what kind of future do we want for ourselves? And I would say that we have a moral and economic imperative to ensure greater college opportunity in our country, not less. Black, Latino, Indigenous, Asian American students make up more than half of all students in our K-12 education system. So the repercussions of not developing that talent and providing them with an equal opportunity to go to college will certainly be damaging to our economy and our nation. So, our focus is really making sure that our policymakers and college leaders remain steadfast in their commitment to close racial gaps, to provide greater opportunity, and really to assess what are the barriers that currently exist that are keeping students out. So specifically, for policymakers and higher education leaders, as Tom mentioned, we need to combat the chilling effect, the myth making that is going to happen when the decision comes out. In California, Lisa has already spoken to this, but we saw an immediate and dramatic decrease in the number of Black and Latino students who applied and were admitted to the most selective University of California campuses. And what was even more dramatic was we saw how many students just chose not to apply at all after Prop 209. We also saw how the ban on affirmative action through Prop 209 in California really obstructed and was interpreted overly conservative in ways that some leaders felt that they couldn't talk about race. They discussed whether they could even have student centers and affinity groups, and whether they could mention diversity in general. It took more than 10 to 15 years for the University of California to recognize that it actually could do a lot more to recruit and support students from all different backgrounds. So my hope is that we will learn from the California experience and that we ensure that there is not an overreach or overinterpretation of the Supreme Court decision. Because of this ruling, university leaders really must examine their current practices. This is also a positive opportunity to identify what are barriers that should be removed, that can be removed. We know that there's a lot to be done in that space. So at the Campaign for College Opportunity, we are focused on understanding the breadth of the decision. As Lisa and others have shared, we don't know the range of what the Supreme Court will say when they do announce the decision. And we want to provide resources on the interpretation with attention to what still can be done. We want to make sure there's not an overreach or an overly conservative response to the decision, which obviously happened in California. In addition, we're also elevating the kinds of practices that have long been inequitable in K-12 schools and in higher education. And we're going to be aggressive about calling those practices out and asking for them to be removed. For example, and I always have found it quite interesting that those who oppose affirmative action have nothing to say about legacy admissions at selective universities, have nothing to say about recruitment practices that campuses perform where they only visit rich, wealthy, predominantly white high schools to recruit students, have nothing to say about early decision and admission practices that overly favor white students, have nothing to say about the use of standardized testing, which is known to, overly favor white students, have nothing to say about financial aid that is merit-based, which again, overly favors white students. There are a lot of practices in higher education that should be challenged and removed. It's really unfortunate that affirmative action is the one that's being attacked today. I'll stop there.
Thank you, Michelle. We have some questions in the chat. So Roran Wang, do you want to ask your question? If not, I can read it. Okay, I'm gonna ask the question. Roran Wang says, does affirmative action result in incompetent students gain admissions and cause unfairness to those who study hard but are not minorities? This is the argument that many people have to oppose affirmative action. Anyone wants to chime in? Michelle or anyone else?
You know, the reality is that there's a lot more prepared students for college today than there are spaces at our colleges and universities. And I would love to see Bloom focus on expanding access to higher education instead of restricting it. This idea of, you know, students not being qualified is simply not informed by the fact that we are preparing more and more young people, and that institutions actually could do a better job at serving them.
If you look at the
Tom, did
statistics,
you want to? Oh, sorry.
so this is John. If you look at the statistics, Harvard could fill its class 4 times over with just valedictorians if they wanted. They could fill their class, I believe, around 2 times over just with people that score perfect scores on their SAT. So certainly these schools are not accepting incompetent students. And if you look at the metrics behind that, these are highly competitive universities. There's no question about that. But I agree with Michelle. What we should be focusing on is expanding more opportunities so that these universities aren't forced to accept just so few, or we create more universities that give more opportunities.
I wanted to ask about polling, because I think Tom or someone else noted that people of color are usually in favor of affirmative action, but when you ask people, should we use race in admissions? The polls don't, the polls are the opposite. People say no. The majority of people say no, we shouldn't use race in admissions. What is going on here? Why the disparity? Anyone?
In my view, it's the rhetoric from the right wing that has been allowed to prevail in discussions of these issues. For example, the most recent question focused on purported unfairness to white students. Okay, that's how this is teed up. It's teed up as somehow unfair to others. And I want to just pause to point out this is how this differs from the Dobbs decision. The Dobbs decision took away a right that women across the country had. But it left open then to states to step in and fill because there was no counter right. The Supreme Court in Dobbs didn't decide, oh, a fetus's rights override the rights of a pregnant woman. They simply decided a pregnant woman does not have a constitutional right, despite the ample evidence to the contrary, and left it open then to states to legislate in their own way. That's why California has done what it has done, and so many other states, including red states, have enacted, since Dobbs, guarantees of reproductive choice. Unfortunately, the affirmative action issue is teed up, as John discussed at length, as some contest between the rights of white, and in this case, Asian American students put up by Ed Bloom, as John has explained, largely falsely, but it's presented as a contest of rights between one set of students, largely white, and another set of students, largely Black and brown. And because what the court will do if it decides to eliminate race-conscious affirmative action is elevate the white students' rights, it will not leave the scope for states to step in as they were able to after Dobbs. That does not mean there are not things that it can be done. Lisa talked a bit about it. Michelle talked about it. And I would simply add that, again, states can be clearer about the obligation to identify racial disparities. Big mismatch, for example, between the percent of high school seniors who are Latino and the percent of Latinos being admitted to flagship universities in a particular state. If there's a big mismatch, something should be done about that. But to do something, you've got to study the disparity, identify what causes it, and address the issue. That's what states can do. It's not as free as it was with Dobbs, which left the issue to state decision. This is going to restrict us more, but it then means that the activism to secure those changes is all the more critical. But back to your question, Pilar, I think people have been misled about affirmative action, largely through this notion that somehow other students, white students, are entitled to overrepresentation, as they've had historically from the beginning of Harvard's existence, that somehow they're entitled to overrepresentation among Harvard students forever into the future. Simply no basis for that conclusion of a right to monopolize the student body at our best universities, or what are reputed to be our best universities.
I have a question for Michelle. Michelle, how do you think overturning affirmative action will affect community college enrollment, which has been dropping?
That's a great question, Pilar. I think one of the big concerns is the big message that is going to come out of the decision when it's released, right? Which in California, we saw just students decide not to apply at all. It could mean that some of those students feel more welcomed and choose to go to community college. But demographically, we're seeing a decline in the young adult population right now. So there are fewer high school graduates every year, and that's going to continue for several years. So I don't know the answer to that. I don't know if Tom or John or Lisa have thought a little bit more about that.
Any of you? Go on.
I think that Michelle is right. We should be very concerned. If this sends a message that somehow you will not have the ability to pursue advancement in education as far as your potential takes you, it could have devastating effects. We've seen this when it comes to undocumented students, as you know, Pilar. When undocumented students didn't have access to higher education, it affected their performance in high school. It affected their performance in middle school. If a similar message somehow gets out that Black, Brown, and Pacific Islander students will not have the opportunity to pursue their education, to pursue the American dream as it has been developed in mythology, that could have devastating effects on kids' ambitions and on their performance.
I know we're focusing on this case and admissions in higher education, but all around us, there are news about states going in and banning books, banning certain conversations in the classroom, banning certain classes. So this is already happening in many places in the country. How do you feel, and this goes for everyone, how do you feel this will affect education in the US? We'll be able to stop that at some point, or this anti-woke, quote unquote, campaign will take us to a place we don't want to go back to?
Let me start by saying that these efforts are just trying to erase our identities, critical portions of our identity. I saw a question, I think was from Henrietta, about Dr. Martin Luther King's quote on the content of our character, not the color of our skin, and how that has been used by the right is to suggest, as Tom would say, race ignorance. Number one, we are not in a race ignorant society. We all know that our racial backgrounds, our ethnicities, are a critical component to who we are. Oftentimes, especially in the Black and Brown community, to our detriment when it comes to policing, when it comes to education. And so part of this is recognizing that that matters, right? And how we consider that. Going to your polling question, part of the issue, right, is how these polls are framed. If the question is presented as, should race determine admissions, I would agree that it shouldn't be the single factor. But that is what is beautiful about the college admissions process, that we are concluding a number of factors. And we could have our discussions about legacy admissions and how they should be framed, whether that is overrepresentative, but that is a factor. And for all of these reasons, to suggest that race cannot be a factor when it's so critical to our identities is just something that for our communities, our vulnerable and impacted communities, is frankly erasure.
And yeah, thank you, John, for those comments. And I just want to add to that. You know, what we're dealing with, and it was so important to make the connection that you made, Pilar, between what we're seeing with the anti-wokeness, with the book bans, et cetera, to what we're seeing with this attempt to eliminate affirmative action and race-conscious admissions. What we're dealing with is a narrative war here, right? This country has always been in a civil war, and it's a narrative war. And we're seeing the heightened narrative war in this sort of post George Floyd murder era. There were lots of gains that we made in terms of shifting the narrative on race after the murder of George Floyd, where people were starting to be more willing to accept the fact that institutional and systemic racism is real, and to accept the fact that we need to actually put in affirmative interventions to create a multicultural, inclusive democracy, right? And so now we're seeing this retrenchment, a pushback on this more inclusive, multicultural narrative that was gaining ground. And again, the pushback is about preserving the master narrative, what Toni Morrison 25 years ago coined as the master narrative, a narrative that centers the experience of whiteness and a narrative that elevates and makes normative the experience of whiteness as the quintessential American experience. And so that's all that this is about, and the continuum that you're seeing between what's happening in states like Florida and Tennessee with these book bans and what's happening across the nation with affirmative action. It is about this narrative war, whether we are going to be an inclusive, multicultural democracy that centers the experience of all people, or whether we are going to continue that legacy of being a democracy that centers the experience of white people.
So, and I would just say, I totally agree that book banning and attacks on ethnic studies are about promoting race ignorance, about promoting erasure. They're in the end about reducing us all to an experience that is largely shaped by a white norm, as Lisa said, but reducing us all to a number. All individual experiences where race and in the book banning, of course, sexual orientation become facts that are not known, facts that are kept under wraps, that has dramatic effects on people's experiences, becomes something that no one believes because the books are banned. That's the ultimate goal, reduces us to a number. But going back to Dr. King's quote and Henrietta's question, you know, a score on a standardized test has nothing to do with someone's character, nothing to do with their intelligence, nothing to do with their merit. Okay, character is about what forms you as a person, what drives you as a person, and that's what these folks want to make irrelevant at this point. So if anything, what we are seeing is directly contrary to the central core of what Dr. King's quote says. We do want to be judged on the content of our character. But in order to get to that, you've got to consider the true evidence of the content of our character. Standardized test doesn't do it, but frankly, a recommendation from a teacher or counselor whose mind is infected by some subconscious bias and stereotype is also not an adequate reflection of a person of color's character.
We already reached and passed the hour. So if anyone wants to say something closing, you're welcome. If not, we'll just end the briefing. I don't know if Michelle or
I would just like to say that, you know, these are all attacks on freedom. You know, if we live in a truly free society, you don't tell me what I can read or not read, who I can study in college. You don't tell educational institutions how they can, not address a compelling interest around diversity. So I just wish that we would talk more about how this Supreme Court has shifted so far to the right to attack freedom and to diminish the contributions of all Americans.
Thank you. Thank you all the panelists and reporters, and please have a good and safe Memorial Day weekend. Bye.